Hey there, I'm the MadCatster. Am I glad to see you here? Well, the Illuminati drama has taken another turn, and you're going to hear it here first, but I have exclusive documents of the lawsuit that she has filed against 3 of her former employees, Oz Media, Wonderstruck, and Felix the KitKat. I obtained the documents from the district court clerk's office down in Colorado, and I've got them here. You know me, I've got the deeds and all the receipts, so buckle up and let's go. So I'm here with Sybil the Enforcer, and Sybil says, please like and subscribe. We've now gone over 31,000 subscribers, so let's see if we can get to 50. That'd be awesome. I quickly want to thank Daffan, Felix, Herman, Lucy, and Binks for sending us some stuff from the cat's Amazon wishlist, which is down below. They sent us 2 things of lightweight cat litter and 1 2-pack of the 20-ounce Friskies treats. Thank you so much. We really, really appreciate it. So let's talk about this lawsuit. So we just talked about how the foreclosure was stopped because Oz raised enough money to pay the cure so that he can keep his house and get back on track with his payments. Well, it takes another wrinkle because Illuminaughtii filed a lawsuit at the same time, mind you, as she was commencing the foreclosure. She filed the lawsuit against not just Oz, but also against Wonderstruck and Felix the KitKat. And the 3 of them are named in the same complaint. And we're going to go over it in just a second. This is an unbelievably weak complaint, in my opinion. And I think the fact that she timed it to happen when she was also commencing the foreclosure, to me, it just seems like overkill. It seems like she's really gunning for Oz. And the other 2, I think, are just like collateral damage. I think she's really piling it on, trying to intimidate him, trying to harass him, in my opinion, and trying to make his life an absolute hell. And you're going to see when we go over this how absolutely ridiculous all of this is. I've also redacted certain allegations in the complaint that Blair has made against Oz and the others, only because they kind of were sensitive. I thought they also were fairly irrelevant to the whole lawsuit. I don't even know why they're in there, but she has listed a bunch of personal stuff that I felt we did not need to go over in order to protect the privacy of those involved. Even though these are public documents, I still don't feel right putting that out there. So what I've left unredacted, believe me, is enough for you to see what this is all about. So let's look at it. So here we've got in the district court, Colorado, it's Blair's company and Blair, who's AKA Illuminaughtii, and against Oz and Wonderstruck and Felix the KitKat. And of course, I've redacted out their names. And you can see here, it says, the plaintiffs, the company and Blair, collectively referred herein as plaintiffs by and through the undersigned counsel, submit their amended complaint, because she filed a complaint and then she went and amended it and added some stuff to it. So what I've got here, what I asked for was the amended complaint, because we don't need to worry about the other one because this one supersedes it. And then against, names of the defendants, the parties in jurisdiction, that the Blair's company is a Colorado limited liability company, and Blair is an individual residing in the state of Colorado, and that the plaintiffs own and operate a popular YouTube channel, presumably the Illuminaughtii channel. And it says the court has subject matter jurisdiction because the events complained of occurred in Colorado, and the resolution of the dispute requires the application of Colorado law. The court has personal jurisdiction over defendants. And it says the action is concerning a breach of contract, declaration of rights, and specific performance related to the defendant's prior employment and agreements thereto. What they're saying is it's basically about them violating their purported, and you'll see why I'm saying that, purported confidentiality agreements, and also claiming that they have defamed her. And I completely disagree with all that. I'll explain a little bit more why I feel that way. And so it just goes to list the defendants and give the dates that they signed their confidentiality agreements. They were all in 2021. And it says collectively, the agreement will be referred to as the agreements, meaning all 3 of the confidentiality agreements. It's all defendants' confidentiality agreements contain language pertaining to the employee's understanding that by entering into the confidentiality agreement, they are obligated to, and plaintiff's goal is to, and now this is important, to protect its confidential proprietary information and ensure that all employees agree to maintain the confidentiality of the company's information. That's important. And we'll talk about in a second why I think that's completely unrelated to what's going on here. Defendant. So Oz and Blair began a romantic relationship in or around May of 2020 and began living together in Oz's house in or around January of 2021. In or around September 2021, Ms. hired Oz to act as project manager for the company. In or around December of 2021, Ms. ended her romantic relationship with Oz. She moved out of his home and she purchased her own home. And, we've heard all that whole story and consequently led to the foreclosure proceedings. Then you'll see I've redacted it. It looks like a lot of stuff, but trust me, it's really personal. It has nothing to do with the company. And I don't believe it has any place in this lawsuit. It says in June of 2023, defendants were sent cease and desist letters from the undersigned law firm. So this past June, they each got a cease and desist because she was alleging that by making the videos and talking about their experiences, that, somehow it was harming her and blah, blah, blah. And it says on July 25th, 2023, a defamatory, now they're calling it defamatory. Of course, that's a matter of their opinion. I disagree. A defamatory video titled The Fall of Iilluminaughtii, YouTube's Biggest Bully, was posted about plaintiffs. The video was published by, and it's not by either Oz or Wonder or Felix. It's by another person, and I've redacted their name because they're not a party to the lawsuit. And it says, in that video, defendants speak publicly about their intent to publish another defamatory video about Blair. So they probably talked about, and I haven't watched that particular video, but they probably talked about the fact that they were going to tell, their side of the story. Because, she had published a video where she made all of these allegations. She made public Wonder's mental health information and facts about him threatening to unalive himself, allegedly, and basically trashing them. And now she's incensed that how dare they actually respond to all this crap that she's thrown out there. It's their perfect right to respond with their side of the story, but somehow it's defamatory and it's breaking their confidentiality agreements. In my opinion, some of the things that she said about, especially like with Wonder, are defamatory. And if I was Wonderstruck and his attorney, I'd be filing my answer and I'd be filing counterclaims against her for defamation and also against her for emotional distress, because what she did by putting out there that information about his mental health definitely, I think, would qualify as something that would trigger intentional infliction of emotional distress. So if you're listening, Wonderstruck, I think you ought to throw this right back in her face. And then it goes on, says, on or about September 16, 2023, defendant released a video titled Let's Talk, an update on Illuminaughtii drama. In this publication, Oz speaks to how he believes that the video will be used in a courtroom and includes false allegations of theft. Well, the fact that he said that he wouldn't be surprised if that video ended up in a courtroom, it's completely irrelevant to this complaint. I think the theft allegation they're talking about, I remember that in his video, Oz had said something about she had said that she needed him to do certain things with, financially, because I think he used the word embezzlement, although he said he wasn't sure what the exact word was. So my guess is that's what they're talking about. And that's basically all she has to say about Oz. And then we move on to Wonderstruck, and it says, prior to Wonder's move to Colorado in or about May of 2021, Blair purchased a car that she allowed him to use as his own, the car. And that's the BMW that, remember, she went and repossessed it after he had driven to his father's in Texas. And it says, under the assumption that he would repay those funds, which Blair and Wonder agreed and understood to be a loan prior to her transferring title to him. In or around the latter part of May 2021, plaintiffs hired Wonder. However, Wonder violated multiple policies of the company despite performing none of his Now, this I think is defamatory too, because I rewatched Wonder's video and he talks about how, he was asking for work, she wouldn't give him work, and Oz backed him up on that, and he was trying to do whatever he could, and that she did 2 live streams that he had to turn into videos, and that one of the deadlines hadn't even been reached, and she terminated him claiming he hadn't met his deadline when it had been moved to August 2nd of that year.
The effort to not be a burden, as it is quite frankly one of my biggest fears in my entire life.
I'm Oz. Y'all know me as Oz Media.
Now, during the month of June, I stayed with you, Oz, and Blair. During this time, did Blair provide work to me as an editor? If this wasn't a case, did you ever witness me personally trying to assist Blair in anything else?
Yeah, I mean, you weren't provided work for like a majority of the time that you were actually employed. I might be wrong on this, but you actively did try to assist her with her the candle shop that she was just starting up, and I mean, she didn't like that, but you were actively trying to seek out and find work. So it's not like you were just like freeloading off of it. From my memory, you were trying to actually earn your keep.
Blair leaving out how long it took her to actually provide content to edit, Blair leaving out that I had asked for work in various other aspects, my deadline extension due to my computer editing software corrupting, not me being lazy, me flying to another state to meet said deadlines with plane tickets provided, and again, proof that I was fired before my deadline even happened. As you can see here in private DMs with an editorial manager, my deadline was extended to August 2nd. I was fired within my deadline.
Despite not performing his job functions, Wonder was paid throughout his time at the company. Now, according to Wonder, that his time with the company was only, I think he said, like 60 days. So it's not like he worked for her forever. And the fact she's accusing him, this document, and in her video, of not doing his job, which has the potential to affect his future employment opportunities, that's defamatory, in my opinion, if what Wonder says is correct. And he did show receipts. So I think she's really skating on thin ice here by making these allegations against him when it appears that there is proof to the contrary. And this is despite agreeing to make payments on and keep the car in Colorado. On or about July 2021, defendant left to Texas with the car and never returned. Now, this gets me too. It's like he agreed to keep it in Colorado, but he left in or about July 2021 and never returned, went to Texas. Well, look at this next paragraph. It says on or about July 28th, 2021. In my understanding, this was only very short period of time after Wonder drove to his father's with the car. And in fact, all of his stuff was still in the car. He hadn't even emptied the car out yet. And that's another thing we'll talk about in a second that is one of his issues with her. Oz and Wonder had had an exchange of communication, and there were screenshots of messages between them where basically they were restructuring the agreement with the car right at this time. And he was supposed to begin making payments in July of 2021.
Though with no work, my only options were being in a home with someone who won't even speak to me, as I believe Oz had gone to visit his father at the time, or I could go visit my father and just spend some time with him. So I chose option 2. I explained the situation to my dad, and I ended up leaving to go see my father so I could spend the 4th of July with him and stay a while so I could mentally reset. I also did digital work, and this was not in violation of my employment, as I could work wherever I wanted via laptop. But before going, Blair had me sign her BMW contract she had been meaning to get to me for a while. She was fully aware of my intent to visit my father and stay a while, especially given that, again, I worked remotely. Blair mentioned she said I was legally bound to this car via contract. However, after I was fired and Colorado was said and done, I had my father, who is an ex-police officer and the former contractor, as well as a lawyer friend of the family, look over and review this legally binding contract. They both agreed that this was in fact not a legally binding contract. I now like to point to a conversation I had with Oz Media, because Blair and I were not on speaking terms at this time, which was something she herself suggested took place between us. July 28th, 2021, one day before the repossession, Oz and I had a phone call together where I stated I would not be moving back to Colorado. He agreed it was probably the best option. Blair informed Oz that she wanted me to pay something that is known as a depreciation value, which is essentially, it's like, okay, you can't pay for the car, so you're going to pay for the value that the car lost while it was in your possession. I agreed. I didn't want further bad blood. I just wanted this whole situation to be done, as it had caused me enough stress as is. Oz gave me a set of options as to what I could do with the car, and I picked option 2, where it was agreed I would bring the car back to Colorado, gather my belongings, and I'd pay the value via regular payments, etc. Later in the early hours of July 29th, 2021, Blair flew down to obtain the BMW. Hours after I agreed to pay for the car's appreciation value under the condition that I was paying what was accurate and visible to me. At roughly 3 a.m., Blair sent me a text stating that I had breached numerous contract violations and that she was in Texas to repossess the vehicle. It goes without saying I was asleep at this time, so obviously I did not see a message that was sent to me at 3 a.m. in the morning. Once I woke up and I saw the messages, I asked Blair for an explanation as to how I breached my contract, to which I was ignored.
When you repossess a car, usually you have to be delinquent at least, I think it's like 2 payments. The document that Blair made Wonder sign before he left for Texas clearly stated that the payments were to begin in July of 2021. So he hadn't even been past due barely 1 payment, and she's repossessing the car. On or about July 28, 2021, Blair flew to Texas to locate her car using the embedded global position system application installed in the car. Blair retrieved her car with her spare key. Now, according to Wonder, the car was parked on his father's property. When Blair recovered the car, she photographed and video recorded it, and we saw in her video that she showed it. There was extensive damage to the car, including a broken glove box and cracks in the windshield. Now, there wasn't extensive damage to the car. That's a line of baloney. All his crap was in the car, and he admitted the car was a mess inside. And he admitted that the latch on the glove compartment had broken and the windshield was cracked because, and I think he showed video of a tractor trailer kicked up a rock and it smashed the window. Well, that happens all the time. I've got 2 chips in my windshield right now from the same hing. He also said he had hit a pothole in the rain, but he said that all of those things were going to be fixed by the BMW dealership under the insurance or under the protection agreement they had for the car. So, whoop-de-doo. Those 3 minor things that were wrong with the car were all going to get fixed. So, she's trying to make it sound like, oh, he was neglectful. Well, those statements are inaccurate. She's repossessing the car in the middle of the night, mind you, off private property when he isn't even in default of the agreement she just made him sign. I think there's a problem there. It says, on or about July 29, 2021, the next day, Wonder and Blair agreed to meet with a police escort so that Wonder could retrieve his belongings that were in the car. Now, Wonder says that meeting never happened and that he sent her several demand letters and he showed copies. So again, these guys have shown receipts. So, I really think that she's made a mistake by bringing this lawsuit. It certainly doesn't make her look any better. Let's just say for argument's sake that she had a legal right to take the car back. She didn't have a legal right to keep his stuff. And he sent her demands, so obviously he had contacted her several times in writing asking for his stuff back. And then Oz had told him that subsequently all that stuff got thrown away. Now you'll see I've redacted paragraph 45 here because Blair makes an allegation that is really disturbing. And not only does it not belong in this complaint, it's really a bad thing of her to do. And if it's not true, it could be defamatory because of what it says. And I'm not even going to hint at what it says. So after Blair left Texas, Blair contacted the police department to perform a wellness check on Wonder. After the wellness check, Wonder contacted Blair stating that she should not contact him any longer. She's abided by this request since the date it was made. Now, that can't really be true, though, because if he sent her demand letters trying to get her to give him back his stuff, that doesn't make any sense. Why would he tell her not to contact him and then send her 3 demand letters? Then there's some more personal stuff that I skipped over that's not relevant to this. In or about May of 2023, Wonder created a 1 hour and 20-minute video with defendant Oz. And that's not really true. They didn't make the video together, but Wonder included a couple of clips of him talking to Oz on video. It says, both defendants made the following claims: that Blair stole Wonder's car and that Blair committed wage theft, when in reality, Blair simply deducted taxes out of Wonder's earnings and other claims. Now, I love the way they do this. They're very, very, very vague. They allude to defamatory statements, but they never say what they are. They're never specific. And they say other claims. Well, this is your complaint. You're supposed to plead all of the facts. You can't just say and other claims because you're not going to be able to bring that in. It's not part of your complaint. And you're saying defamatory statements, but you're not saying what was defamatory. And now they're saying that they claim that she stole the car. They did not say that. I rewatched Wonder's whole video. At no time did he say Blair stole the car. He said she repossessed it in the middle of the night. A couple of times he referenced when Blair took the car, but he didn't say stole, meaning when she came and took the car away. And about the wage theft, he didn't accuse her of wage theft. During the video, both defendants openly state that they are aware of the non-disclosure language of their agreements. Okay, whoop-de-doo. After the video was produced, Blair sent a cease and desist letter to Wonder. He reacted by starting a GoFundMe page seeking money to pay for legal fees. What does that have anything to do with this? What are they trying to say? That means he's acknowledging he broke it? All that means is she sends him a cease and desist. He says, oh my God, she's getting legal. I don't have any money to pay a lawyer. I better get money so I can pay a lawyer to defend myself. There's nothing wrong with that. He's entitled to do that. The fact that he started a GoFundMe is irrelevant to this whole thing, and that's an erroneous fact that doesn't belong in this complaint. For Felix the KitKat, his, I think, they're all lame and they're all weak, and in my opinion, none of them holds water. But this, of all of the 3 defendants, is the most ridiculous one. It's like, why is he even in this? Let's talk about what put a bug up Blair's ass that Felix the KitKat did. All right? Defendant Felix is a former employee of the plaintiffs. Felix is in violation of the agreement by turning over private messages between he and Blair to a YouTuber to exploit in a video made to slander plaintiffs. Okay, first of all, I talked to Felix and he pointed out something really interesting. If you've been following all this stuff, you've probably seen these before. Here are the messages. And this is basically when she's asking Felix to find stuff on the click to try to make him look bad. And she's offering to pay Felix $200 to do that. She's claiming that these were all edited out of order. He says, no, they're not. He's redacted a line here, but he said that these are not out of order. The way he's presented them is a completely accurate presentation of the conversation. I'm going to give him the benefit of the doubt. But here's the important part on this. Look at the date on these. November 10th, 2020. Now, why is that significant? Because he didn't go to work for her until 2021. She's alleging that his confidentiality agreement, which was created in 2021, somehow retroactively covers personal communications between the two of them a year before. That's not how it works. You can't retroactively protect private communication. First of all, private communication, from what I understand of the confidentiality agreement, isn't even part of it. So this whole claim is bogus, in my opinion. And in my opinion, this is what we call malicious prosecution, where she's just doing this to spite him. And because she's angry that he revealed their private communication. Revealing a private communication isn't defamatory because clearly the language is there to read. So he didn't allege something that wasn't in writing. And second of all, it was a year before he worked for her. It has nothing to do with his confidentiality agreement. This whole part of it should be dismissed. He shouldn't even be in this lawsuit, in my opinion. If I were him, I'd countersue her as well for malicious prosecution. You know, and teach her a lesson. People use the legal system sometimes in abusive ways. And you'll see here in paragraph 55, it says, defendant Felix edited selectively picked messages to create the appearance that Blair made statements that she did not. If you read through those, how did he manipulate them that way? He took them from actual messages. He didn't rearrange the language. So if he has, the time and date stamps for that stuff, she said it if it's in the message. So she claims that his editing created a false narrative that was damaging to plaintiffs. And again, according to him, that's not the case. First claim for relief. Now, this is the breach of contract. So this is the allegations that they breached the non-disclosure agreement. Now, my understanding of the non-disclosure agreement is it's for 25 years. 25 years. In almost every state, that would be considered to be an unreasonable amount of time. I went to look to see, what does Colorado consider to be reasonable? And it says that 2 years, sometimes maybe 3 years, is what the courts view as reasonable. In my opinion, based on that, these non-disclosure agreements are unenforceable because it's for an unconscionable amount of time. It's ridiculously long. Not only that, they're geared specifically to a high-tech company, like a software development, that the language that's used in them is like boilerplate. It's the type of language that you would see in an agreement for a software developer, protecting trade secrets and other proprietary information. And that's what they call it here, proprietary information, so that you wouldn't give to competitors the information on the product and the processes that the company uses to make its product. Well, this isn't an entertainment production company. It's not a software developer. So I don't even think that the kind of proprietary information that they claim they're protecting is even relevant to the allegations that they're making here. I think that these agreements are rubbish, in my opinion. All right, so let's go through now the breach of contract claim here. It says Blair and her company hereby incorporate the previous paragraphs by reference. Plaintiffs and defendants have entered into valid, they're calling them valid. I don't think so, in my opinion. Valid and binding contracts supported by adequate consideration. Consideration means usually your employment. The agreements contain the following language. Employee agrees not to use confidential information and or proprietary data now this is the important part, for the benefit of any other person, corporation, or entity other than the employer during the term of employee's employment with employer or any time thereafter. That right there means in perpetuity. You can't have an agreement that just goes on forever. You can't bind them to never saying anything for the rest of eternity. That's not reasonable. Confidential information means, like, again, corporate information. It doesn't mean Blair said this to me, or we had these private texts and so she doesn't want them made public. That's a whole different kind of non-disclosure agreement. It's not this kind of non-disclosure agreement. And they didn't use confidential information or proprietary data for the benefit of any other person. The stuff that they said was based on their personal opinions and experiences. It wasn't to help somebody else. It wasn't like giving somebody's competitor the secret formula to help them out. So this paragraph that they put here that they're citing to, it doesn't even apply to this situation, in my opinion. So what is it doing here? Why do we even have a claim for breach of contract? Because this paragraph they specifically list is not applicable, in my opinion. Upon information and belief, defendants are in breach of these agreements by not exhaustively. So again, not exhaustively. So they're saying these things is what they're in breach of, but that's not the whole list. Well, yes, it is. Because the complaint is your time to set out with specificity what it is you're saying the defendant did that caused you harm. If it's not worth your time to list it here, it's not part of the lawsuit. Why even use those words? Because whatever you've listed here, that's it. By not exhaustively using confidential or proprietary information to defame or otherwise harm plaintiffs, defendants have further established their intent to post additional content which will harm plaintiffs in a devastating manner. Now, whether or not they've said that they intend to make any more videos or any other content on social media is not relevant. You cannot have a claim for something that might happen in the future. You can only have a claim for something that's already happened. So that's completely irrelevant as well. As a result of defendants' breaches, plaintiffs have incurred damages, including but not limited to loss of revenue, future loss of revenue, pain and suffering, and attorney's fees. Good luck proving that. Because, as you all know, people have been trashing her for months now. And most of it stemmed back to when she accused Legal Eagle of stealing her editing techniques, which weren't even her editing techniques. And all of this stuff that's gone on about how she's been accused of plagiarizing stuff, where people have shown evidence of that in videos. The defendants aren't responsible for all of that. Her decline is not based on the videos that they're citing here. It's based on a whole tornado of stuff that's blown up about her. She can't pin her whole decline on these three individuals and the limited things they've done, which I don't believe are defamatory or violation of their confidentiality agreements. And then the second claim for relief is the defamation claim, which I think is equally as weak. Blair and the company hereby incorporate the previous paragraphs by reference as though each were fully set forth therein. The defendants published or caused to be published false statements that Blair committed various acts, including abuse to her employees, wage theft, vehicular theft, and other claims. And again, there's that and other claims. What are the other claims? You can't say and or other claims. You have to specify here because the defendants have to be able to answer these allegations. And if they're not set out here in detail, they can't answer them. And therefore, if they're not set out in detail here, tough luck for you. With respect to including abuse to her employees, now, Oz and Wonder, a lot of the stuff that they were talking about was stuff that occurred in the personal sphere, outside of the company, and in their living arrangement, in their interpersonal relationship. That has nothing to do with the company. Those things are opinions and of their viewpoint of what happened. Opinions are not defamation. You can see here, it says, you can't take somebody's opinion of, like, if I give you my opinion of that I thought that my employer was crappy to me and it really hurt me and I felt that they were unfair to me, that's my opinion. I'm entitled to it. It's not defamation. And again, we talked about the wage theft. He didn't say she was guilty of wage theft. He didn't say she was guilty of vehicular theft. This is so weak. And there's such a lack of specificity that it's really a lot of nothing, to be honest. You can't answer this complaint fully when you're a defendant because she's not telling you exactly what it is she's claiming you did. She's making vague statements. You can't answer vagaries and broad statements. You have to cite to specifically what did they say, specifically what did they do, when did they do it, where did it happen. Then they can answer it and say, no, that's not true on that date, or I did not say that. When there's nothing specific in here, there's nothing to answer. This claim is rubbish, in my opinion. So they say that, the statements were defamatory because they tended to harm Blair's reputation by lowering her in the estimation of at least a substantial and respectable minority of the community. I think that there's a lot more that's responsible for that than these three guys. The statements were directly made about Blair, as alleged herein. The defendants were acting with actual malice. Now, that means that they deliberately were doing it just to spite her or to get her. That's not what they were doing. She made a video where she made all these allegations and she said all of these nasty things about people. They then made response videos. It's not actual malice when you're defending yourself against the crap allegations that she spewed out there. Knowing that they were false while recklessly disregarding whether they were true or false when published. I don't think that's true either. They believe that they're not true. They showed receipts. They firmly are of the opinion that they are not true. So it wasn't reckless. The viewers, readers, or listeners of these defamatory statements likely understood them as true. They're talking about their experience, their viewpoint, and they're also rebutting crap that she said. So why isn't what she said defamatory? I think more than one of these guys should counterclaim her for defamation. Given Blair's business as a professional media personality and as a direct and proximate result of their defamation of Blair, defendants have caused her and will cause her to incur special damages as alleged herein. The defamatory nature of these publications was apparent on their face because they alleged commissions of criminal offenses, and they were allegations incompatible with Blair's business, trade, profession, or office. These are all legal elements that they're setting out there that they're trying to say are met, that they have to meet in order to prove that this is defamation. These publications were made regarding Blair, and Blair suffered non-economic and special damages as a result of their publications. Non-economic, I guess they're talking about reputation versus, loss of income on her channel. But again, I don't think these three are responsible for that. I think a lot of it she's done herself, and a lot of it has also come from other spheres of the social media world. And then they're asking for the court to enter judgment in favor of the plaintiff, including award of pre- and post-judgment interest, attorney's fees and costs, and any other relief that's deemed reasonable and necessary. Now, know that from the docket that Oz's team has filed a motion to dismiss, and Blair has now filed her opposition to their motion to dismiss. Usually when I talk about these motions to dismiss, I say, the court usually gives a lot of latitude to the plaintiff and takes everything they say is true. And we talked about, like, with Sausage and Sniper Wolf, how I was confident that the court was not going to grant her motion to dismiss because his claims were plausible, and therefore the court should give him the benefit of the doubt, and that's usually how it works. Now, with this particular complaint, I give that motion to dismiss a better than 50% chance of succeeding. Only because there's such a lack of detail and specificity in this complaint. It's a lot of very broad and very vague information and very vague allegations that she's made without really any specifics to back it up. There aren't any exact statements. There aren't any dates. There aren't any times. You know, all of the things that you would expect to see in a complaint when you're laying out your case. And none of that is really in here. So I give Oz's chance of succeeding on that motion to dismiss a better than 50% chance in this particular instance. In my opinion, this complaint, because it is so vague and because it is so lacking in detail, it's really harassment, in my opinion. I think this is designed to harass, intimidate, and just basically cost them legal fees and upend their lives. And I think it's really just one more shitty notch in Blair's belt. And I think she's going to fall flat here. Let me know what you think down below. I'd like to hear your opinions. Thank you so much to our channel members, our Patreon patrons. Thank you for all of your support. We really, really, really appreciate you guys. There's another video coming shortly. But in the interim, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.